Welcome to Focus on Seniors, a television show sponsored by Helping Seniors of Brevard County, Florida. The show is designed to make you aware of senior issues, needs, and resources available to help us age in place and with dignity. This show will help you as you develop your own aging and care plan.
I'm Joe Steckler, and welcome to Focus on Seniors, the television arm of Helping Seniors of Brevard County, a show designed to provide you with information on how to develop your own aging and care plans. Our topic today is legal documents and estate planning. With me in the studio is William Johnson, elder law attorney. Welcome, Bill.
Thank you, Joe.
I'm glad to have you here. It's you know, we've filmed many shows in the past. We've done radio shows. You are a writer in our column in the newspaper. But it's exciting to me to start this new series, Focus on Seniors, because I think there's so much information that we can give to people that need help.
I would agree.
Yeah, and you and I have talked so many times about different aspects of the law and legal aspects of planning. But folks, it was my privilege, roughly several weeks ago, to sit on one of Bill's planning sessions with a family, and I learned a lot from watching how Bill explained to families the necessity to do some of these things. And I can tell you firsthand, you can think about it and they can talk about it, Bill, all they want, but until you sit across the table from an attorney and the attorney opens a book up and explains things to you, the impact is not there.
Correct. And usually, a lot of the, especially incapacity planning stuff is always in some sort of crisis mode usually. And we like to get everything done ahead of time, so we don't have any problems down the road. And
I was, in fact, as many times that we talked about DNRs do not necessitate healthcare surrogate documents and everything, living wills, I find myself, when I review these documents prior to some of our taping sessions, that I realize that it's easy to forget.
Correct. And to update.
Yeah.
A lot of people do these, squirrel them away for 10 years and think they're all going to be ready to go when they need them. And a lot changes in that time period.
Yeah, but think about the people that don't even take the time or don't even spend a little money or take advantage of a free consultation with an attorney to find out how little they do know.
Or even if the documents they have are still good. So we get that a lot. People bring in documents, and I just saw a will from 1960, and somebody was worried about whether or not it was going to be valid. So a lot of things can change, especially with not so much wills and trusts, but a lot of the other documents. There's can be some headaches.
Yes, and over this new series of Focus on Seniors taping sessions, where we're going to talk about medical, legal, just plain old everyday living for seniors. I think that the new Focus on Seniors sessions for our legal documentation is going to be more informative, because you and I both have learned over the last, we've been doing this now 6, 7, 8 years.
Yeah, long time.
So it makes a lot of difference. But today, the focus of our show is legal documents and estate planning. And I think one of the first things I'd like to talk about, one of my first questions was, what does an elder law attorney do?
What does an elder law attorney? Yeah. Basically, unlike other areas of law, we service a population. So we're mainly dealing with people 55 and over with their legal needs. We do estate planning, we do nursing home planning, incapacity planning, guardianships, probate, all those things that basically that population needs. Differentiate that from like a real estate attorney. They deal with mainly an area of law. So an elder law attorney is dealing with a senior population. That's the main difference.
And I could probably talk till I was blue in the face about the importance of seeing a specialized attorney for different aspects of what you're trying to do. And invariably people will go to their friend, and I can understand going to a friend. But try as the friend might, there are certain aspects of elder law, estate planning, trust planning, and Medicaid planning in particular, that it takes someone versed and knowledgeable in all aspects of that planning to get the job done correctly.
I would agree with that. And, the Florida Bar does have a way of separating out attorneys. That's through bar certification in different areas. I'm board certified in elder law, but that's, how you can separate out people who are specialists in the area from people who might not have that specialized knowledge.
Okay. Having said all this, what basic documents make up estate planning?
Well, in Florida, you're mainly looking at 5 or 6 documents. Everybody should have a will, and then you should have a durable power of attorney, a designation of healthcare surrogate, a living will, a pre-need guardian declaration, and then depending on your estate, you may want to add a revocable living trust. So you have 5 or 6 documents that make up a basic estate and incapacity plan.
Yeah, I had something I was going to... You mentioned living will.
Correct.
Folks, I had this package. I don't know where I got it, but it talks about advance directives.
Right.
And I pulled out my package, my legal document stuff, and I looked at it and I saw living will and, what was the other thing?
Healthcare surrogate.
Yeah,
usually the two that make up the advance directives.
So many people don't understand the difference between those two documents.
Well, a healthcare surrogate is a document where you name somebody to make your healthcare decisions once a doctor deems you lack the capacity to give informed consent. A living will is your wishes on whether or not you want life support continued if you're in a incapacitated state, and in usually one of 3 states, an end-stage condition, a terminal condition, or a persistent vegetative state, and then also whether or not you want a feeding tube in those situations. So a living will is a statement of your wishes. A healthcare surrogate is the designation of somebody to make your healthcare decisions. And if those two happen to conflict, the living will trumps the healthcare surrogate. But there are a lot of healthcare decisions that aren't end-of-life decisions. For example, if you have somebody with dementia and you have to determine what doctors they go to, where they live, whether or not they're going to get an operation, those aren't end-of-life decisions. But a living will typically are what your wishes are for your end-of-life decisions.
But I had this, and I got a question came up in my own mind. It's like it says, a DNR is a document that specifies the patient does not want to be resuscitated.
Okay.
Now,
there's a difference between a living will and a DNR, too.
That's the point I want you to make.
A living will is you're alive, but the machines are keeping you alive. Think ventilator, feeding tube, something of that nature. And that's just prolonging the dying process. On the other hand, a do not resuscitate order is you've died, and whether or not you want to be brought back to life. Think paddles. So that's the main difference. Do not resuscitate is whether or not you want them to resuscitate you. Usually that involves the paddles, versus a living will, which is you're alive, but the machines are just prolonging the dying process.
And people get that confused all the time.
Correct. People think they have a DNR and they think that's a living will, or they have a living will and they think that's a DNR. And they are actually 2 different documents. In Florida, we have a standard form for a do not resuscitate order. It must be executed by you and your physician. You can get them at your doctor's office. We do have statutory forms for living wills and healthcare surrogates. And if you go to the hospital, most hospitals hand those out for people to fill out. Some doctors' offices carry those forms as well.
See, this is why I think it's important, Bill, that when people have these types of documents to fill out, they go to somebody like you that can explain to them the differences so that families don't come up and say, well, this is what I wanted to have happen, but it couldn't happen.
Correct. And there are certain special execution requirements for healthcare surrogate and living will. You have to have 2 witnesses. One of them can't be a relative, and none of the witnesses can actually be the people named in the document.
And that's important.
Well, it's very important because people pick these forms up, and where do they sign them? With their family around, So you got to really watch out on whether or not you have the right witnesses, the correct number of witnesses, and you have to have somebody who is basically impartial as a witness too.
Bill, another area about estate planning and legal documents that people seem to have a misconception about is the importance of a will. And
well, let's talk about that. There are a lot of ways you can leave your assets onto your heirs, a will being one of them. There are a lot of other ways as well now, trust, pay on death accounts, beneficiary designations, joint titling. So there are a lot of different ways you can move assets to heirs, the will being probably the most well-known of all those. But everybody at a minimum should have a will, and it should spell out who you want as your personal representative, that's Florida's term for executor, and how you want to distribute your estate upon your death. Now, a will is only going to cover those assets that are in your name alone when you pass on. Assets that aren't jointly titled with anybody and don't have a beneficiary designation on them. Now, one of the things, or a common misconception out there, is that wills avoid probate. Wills go through probate. Probate is from Latin, meaning to prove the will's valid, and so wills go through a process known as probate. Currently, that takes about 12 months. There are some fees associated with that. So at a minimum, you should have a will, and that is your basically safety net. However, if you can, you really want to avoid the probate process. And there are three main different ways of doing that. Probably the most common, or one of the most common ways of doing that, is just own assets jointly. Like as a husband and wife, they own a bank account together. One of them passes, the other one inherits the account. You can do that with other relatives or children. You can make accounts joint title with right of survivorship. Though it might not be a very good idea to add kids' names to accounts, especially if they have a strong likelihood that they may get sued or file bankruptcy or be in a dissolution of marriage situation. Those assets of yours might get dragged into that situation. Now, you can also make bank accounts and brokerage accounts transfer upon your death. For bank accounts, that's called payable on death. For securities accounts, that's transfer on death. And so you can actually put beneficiary designations on those two types of assets. Most people are familiar with beneficiary designations on life insurance, IRAs, annuities, 403bs, 401ks. And all those assets, simply you present, or your heirs present, a death certificate, and if all the account holders are deceased, then that account will pay out to whoever you've named as a beneficiary. Then the third way, of course, is to create a revocable living trust. A trust is basically an agreement initially between you and yourself. You're the grantor, meaning you create the trust. You're also the trustee, the one managing the trust, and during your lifetime, you're the beneficiary. When you become incapacitated or pass on, then someone known as a successor trustee steps up and manages the trust. If you have passed on, then that trustee would muster your assets, pay your bills, and distribute the assets to your heirs, and that being the assets that are titled in the name of the trust. Because that successor trustee steps up and does that job, we don't have to go through probate. So 3 ways you can avoid probate: joint title, beneficiary designations, transfer on death, pay on death, and outright beneficiary designations, or put the asset in a revocable living trust. Now, if you have a will, that's going to cover those assets that aren't in a trust, didn't have a joint owner, and didn't have a beneficiary on them. And then that will is going to, or that asset will go through the probate process. If you die without a will, Florida does have a statute called the intestacy statute that will determine who gets your assets.
And quite often the state gets the assets.
The state rarely gets any assets because usually we can find some heir.
Okay.
Usually there is somebody out there somewhere that is a blood relative. And it may, go out cousins, second cousins, third cousins, but usually you can find somebody out there who is an heir to the property.
To put in perspective what you're talking about, let's just, because it'll have a lot of zeros in it. Let's say that somebody has an estate of $1 million, and it has to go through probate.
Right.
What is the approximate probate cost?
Okay, in Florida, by statute, the attorneys can charge 3% of the value of that asset. So that would be a $30,000 probate bill. And that is presumed to be reasonable under Florida's probate statute. So I just gave you 3 ways to avoid that fee: trust, joint title, and pay on death beneficiary accounts.
What is the most common way to do it?
Well, we don't probate a lot of assets anymore. It used to be probate was fairly common. Now it is more uncommon. People with substantial assets either do a trust, or they are aware that they have beneficiary designations or joint title. And we see a general awareness in the public of being able to name beneficiaries on assets. If you think about it, a lot of people work all their life and contribute to a 401k. When they retire, it becomes an IRA. And on that IRA, you name, your primary beneficiary and your contingent. And that is going to avoid probate. Unless, of course, you name the estate as your beneficiary, which is not advisable.
I don't think it's advisable to do that.
That would run the whole thing through probate.
But, here we are. We've called this thing legal documents and estate planning. Everything that you've talked about so far is part of what a good estate plan should contain.
Correct. And there are a lot of different questions that I get when people come in to talk about estate planning, because there's a lot of misconceptions out in the public. And if you can come in and talk to an attorney who does estate planning, they can clear a lot of that up. Most people don't know that Florida does not have an inheritance tax. So when you pass away in Florida, there is no state tax that's going to come in and tax your estate. The federal estate tax kicks in at estates over $5 million. So for the most part, most of us don't have any estate tax worries in Florida.
But having said that, many people don't realize how large their estate really is. Many people don't think about all the assets that they have to count.
Well, the number one mistake a lot of people make, and usually this is people in their 40s and 50s, is they do not include in the value of their estate life insurance proceeds. And they carry these, $2-3 million life insurance policies that pay out if they die, and they don't include that when they value their estate. The other one, most of the assets I just talked about, we were talking about liquid assets. There are also illiquid, real estate, and things like that can add a hefty dollar value to an estate.
Especially when you were thinking today, I happen to think that term insurance is a smart buy.
Well, usually most people take out term insurance if they want to protect the loss of the earning capacity of one of the spouses in a family situation.
Now, in thinking about legal documents, estate planning, thinking about the unknown, the other little document I had marked down here, the importance of a durable power of attorney.
Okay, and let's differentiate that from a will.
Okay.
A lot of people think if they become incapacitated, their executor takes over, their personal representative named in the will. And that's not true. The executor takes over when you pass away, okay? So prior to that, if you have a stroke or if you have dementia or any Parkinson's, number of diseases, we might need somebody to come in and manage your finances, pay your bills, pay your for your long-term care costs, sell assets, buy assets, that kind of thing.
Manage your financial estate.
Yeah, usually everything to do with your financial estate. And that document's called a durable power of attorney. Now, durable means that it survives the incapacity of the person making the document. And usually there's a clause in there, or it's required that there be a clause in there that says this document shall not be affected by the subsequent mental or physical incapacity of the maker. Something to that effect.
Right.
As long as it has that clause in there, it is a durable power of attorney. And usually in a durable power of attorney, we give a broad grant of authority to someone to manage all your financial affairs. Write checks, sign contracts, sign tax returns, apply for public benefits, buy, sell securities, a whole wide range. Now, one of the interesting things to note is Florida just passed a brand new durable power of attorney statute that took effect October 1st of last year. Now, this is one of those things that we were talking about at the beginning of the show. It's one of those gotcha moments.
Yeah.
Because we're beginning to see people come into my office who have powers of attorney that they've bought at these office supply stores or downloaded off the internet, who have no idea that the law has changed. And the requirements of the new law are that certain types of powers, if you're going to give them to somebody, the person signing the document actually has to initial next to it or sign next to that grant of authority. In other words, they almost have to specifically authorize that.
It has to be specifically authorized.
Correct. A good example is the power to create a trust. Because in Medicaid planning, a lot of times we have to create something called a qualified income trust.
And we're going to do a whole show on that.
Yeah, and we need a power of attorney that gives that power to somebody to do that. Now, under the new law, you have to sign off on that clause. And we're getting people in our office who have, these store-bought powers of attorney where the person making the power of attorney has not signed off on that kind of clause and subsequently has not given their designated person those powers. And that creates a whole nother level of frustration and legal entanglement just because the power of attorney is not good.
Let's say you got a husband and wife, and things are all in both people's names.
Well, let's talk about that, because I get that question. Why do we need a power of attorney if we own everything jointly as husband and wife? Well, I bet there are certain assets that you don't own jointly. Good example, your Social Security check comes in one name. Usually the pension check comes in one name. If there's any IRAs, 403Bs, 401Ks, those are usually only in one name. So, if you have somebody and their spouse is sick and the other spouse needs to get in the 401K to pay for the costs of care, if they don't have a power of attorney, they're not doing it. They're going to guardianship court. Say you own the house jointly and one of you is incapacitated and you need to downsize your house. Well, if you don't have a power of attorney, you can't sign your spouse's name. That's an important point. There is no authority for a spouse to sign the other spouse's name unless that authority has been granted. So usually that is through a durable power of attorney.
I want you to say that. We use the word power of attorney, and sometimes we think many people think it's interchangeable, but I believe that a durable power of attorney is the most effective power of attorney to have. Am I right or wrong?
You are correct. It's the most wonderful document. It's also the worst document. Because if you give it to somebody you can't trust, they really can rob you blind. And I could tell you horror story after horror story. But if used right, it is a wonderful document that prevents families having to go to guardianship court.
And I think you have to make a few assumptions in planning an estate, Bill, that you got to figure that somebody that you're going to trust somebody somewhere along the line here.
Yeah, if you notice in all these documents, we're talking about, for the most part, naming individuals to make your healthcare decisions, your financial decisions, administer your estate, and it's got to be somebody you can trust. You're exactly right. And, one of the issues that faces seniors, especially with the number of people living into their 90s or even past 100, is they tend to start outliving all their friends. And they may not have people that they can trust in those roles.
Yeah.
So that becomes an issue sometimes with the extreme elderly.
Years before, when I was a young man, families had an attorney, and if the attorney was older and had a son or something who became an attorney, so everything sort of automatically passed to that guy, and he took care of you.
Correct.
And I don't know how much that happens anymore because we've changed.
It does happen somewhat. Yeah.
It does happen?
Yeah, it does happen. There are quite a few law firms here locally that are passing down generation to generation.
Yeah. Another area that talking about, and we're almost out of time, but another great part of estate planning, especially when we talk about dementia, are guardianships.
Yeah, and I'll briefly, the last document I had talked about was the Pre-Knead Guardian Declaration. Guardianships where we go to court and have somebody legally declared incapacitated, and what happens in that process is we appoint somebody to exercise that person's rights for them, and that person's known as a guardian. If you have more than one person coming into the court system to be somebody's guardian, you can end up with a trial. So the way you protect yourself is ahead of time you do what's called a Pre-Knead Guardian Declaration, spelling out who you want to be your guardian in the event a guardianship is filed, and then that creates a presumption in favor of that person, and absent that person, being the one who's stealing from you or something like that, the court's going to appoint them to that role as guardian.
In a little bit of time we got left, I want to just take that guardianship just a little bit further. Having been involved as a layperson in a number of cases, and I've worked directly with you on some of these things, I have found that if a family can think about whether or not they need to establish some type of a guardianship before they get to the point where they absolutely must do it, it's easier on the family, it's less costly, and it can be done with a minimum of effort.
Well, if you can get somebody before they become incapacitated and get them to do all the documents that we just talked about, you can save yourself a whole heck of a lot of money and avoid guardianship court.
Yeah. We got about a minute left. Is there any specific thing that you'd tell somebody about?
One thing I would really like to point out to everybody is the importance of all these documents if you have an extended family. Most people don't know that 50% of seniors age 65 or older have an extended family, meaning they've either been divorced and remarried, or they're widowed or widower and remarried, and they have kids from a prior marriage with a new spouse. And 90% of the litigation I do, whether it be probate, trust litigation, guardianship litigation, typically involves a second or later spouse versus kids from a prior marriage.
Good. Thank you, Bill.
Oh, you're welcome, Joe.
I appreciate what you say because it's so important. And thank you today, viewers, for watching today's episode of Focus on Seniors. If you have questions or comments, please call radio station WMEL AM 1300 at 321-631-1300. For more information on senior care and resources, visit our website, helpingseniorsofbrevard.com. And I hope you've enjoyed today's show as much as I've enjoyed having Bill here in the studio to make you aware of ways you can help understand your legal documents and do a better job of estate planning. Thank you for watching.